Hello, ladies and gentlemen. Today in this class, I will be taking your on polity. Something I will discuss regarding the polity. And the chapter is the President of India. It's a very interesting chapter to discuss about. Before we go further, I would like to introduce myself. Here, my name is Saurav, and I'm an educator in SSB Sure Short Academy. Mainly, we focus on the preparation for CDS, AFCAT, and NDA candidates, offline and for online both. Our next batches are starting from 21st of this month for CDS and NDA both. So ladies and gentlemen, let us come into the discussion, and before I proceed, I will take your lecture, and after the completion of lecture, we will have some doubt session, and in that it means once the lecture gets over, you can write down your doubt and we will discuss it at last. So President of India, as all of us know, the parliament is comprising of Lok Sabha, Rajya Sabha and President of India. So today in this class we will discuss regarding the President of India. All detail about President of India for the examination point of view of CDS, AFCAT and NDA exams. So first of all, let us discuss Article 52, which talks about that there shall be office of President in India. So Article 52 says that there should be office of President of India, and what are the constitutional positions are there given to the President of India is he is only the constitutional head, titular head, de jure head or nominal executive or just a symbolic head. So that is the constitutional position of that is the constitutional position of Indian president, right? So when we say the President of India is just a constitutional head, it means the all executive power is being enjoyed by the cabinet ministry and the council of ministers, right? So the President of India is just a head for the title point of view, for just de jure head. It means that is the right of the post, whichever person comes to the post of President of India, by the right of that post becomes the power is there. So that is the de jure head or nominal executive, just for the namesake. There is no such power which is directly or independently enjoyed by the President of India. So these things we will be understanding in the coming slides and in the coming discussion. He is the Supreme Commander of Defense Forces in India. This is known to all of you because starting from the class 6 onwards in general knowledge, we understand that the President of India is the Supreme Commander of Defense Forces. Now, the President of India is the head of the Union Executive, is the President. It's a Union Executive. So, I'm damn sure that most of you, sometimes candidates get confused regarding the executive, legislation and judiciary in India. So, those bodies which are totally there to make laws are comes under the legislative bodies. Like all the elected MLAs are comes under the legislative bodies who makes law. Executive bodies are those bodies who make these laws execute well on the ground. It means to follow the laws. That is the executive bodies. For example, see the defense forces, the officers and the all defense personnel comes under the executive personnels, like IPS, Indian civil service, like collector, district magistrate, diplomats. These all comes under the what we say executive body. Who is the head of this executive body? President of India is the head of Union Executive. Okay. Then comes, it also includes the PM and Council of Ministers. When we talk about the executive bodies, it means those bodies, the Council of Ministers, which includes the cabinet ministries and the Prime Minister. So first, the Council of Ministers. So the Council of Minister is not necessarily will be the member of cabinet minister, but a person, if he is the member of cabinet ministries, then obviously he or she, that person is the member of council ministry. It means you, in the mathematical language, you can understand that the cabinet ministries is the subset of council of minister. Then comes the real executive powers are vested in the councils of ministers. So real executive powers is vested in the council of minister, but these powers, any of the decisions are taken on the name of the President of India. What Article 53 says, let us understand this. The exact terminology which is used in the Article 53, you can see it, read it here. The executive powers of the President are exercised by him directly or through officers subordinate to him in accordance with the Constitution. So executive powers of the President are exercised by President. On the name of President itself, we take any of the executive decisions. Okay? But these will be exercised by any of the persons appointed by the President. So name is there of the President. That is why we say the President of India is just a tutelar head or symbolic head, you say the constitutional head, de jure head. That is the meaning of this. Next comes the election. So let us now discuss how the election of the President of India is carried out. So in India, what is the, there are so many different types of election in the various political parties. Like in general election, see, the presidential election is somehow different from the general election. And how to understand this? Most of the time these questions are asked in the interviews, and several whenever there is a check, someone wants to test you of your understanding of this Indian polity, then they will, these are the basic questions which are asked from the students and which are expected from the students, that they should know the difference between the general election and the election of the president. Mostly those students who all are preparing for defense, those who all are the defense aspirant, they can understand, for them it is very necessary to understand this thing, because in interview also sometimes it is asked, can you please distinguish between the election process of president and the election general election process. So first of all, elected via indirect election. So we should understand that the President of India is elected by the indirect elections. So when we talk about the indirect elections, it means we the people of India not directly participate in the presidential elections. So there is some electoral college formed for the participation of the presidential election. So now we will understand that who all are the part of electoral college for the presidential election. Okay? So electoral college in accordance with the system of proportional representation by means of single transferable vote. So ladies and gentlemen, you might be feeling here a bit difficult to understand this proportional representation by means of single transferable vote. So this meaning plays a very important role in the election process of President of India. Next comes C. So electoral college is according. So who all are the members? So first of all elected members, all elected members of both the House of Parliament, that is Rajya Sabha and the Lok Sabha. So when we talk only elected members, then it comes that all the members who all are elected, not nominated. All of you must be knowing that in Rajya Sabha 12 members are nominated by the President of India on a special ground. Okay? Like Jaya Bachchan, you might have heard Sachin Tendulkar was also appointed in the Rajya Sabha. Okay? Next comes the elected members of, when we talk about the elected members of a state, it means they all include the MLAs, member of legislative assemblies, not the member of legislative council. So the member of legislative assemblies only, because they all are directly elected by the people of the different constituency in the state. So those MLAs are the part of electoral college of the election process of President of India. Then comes the elected members of the state and UTs. So when we say state, you understood MLAs and UT. In some of the union territories also. Which are the union territories? Like in Delhi, there is a legislative assembly. In Jammu and Kashmir, there is a legislative assembly. In Puducherry, there is a legislative assembly. But ladies and gentlemen, here one thing you need to keep in your mind, that in Jammu and Kashmir, it's not yet finalized that the legislative assembly is there in Jammu and Kashmir, but will they participate in the presidential election or not? Because our article 54, according to article 54, the member of a state and UTs the elected members of a state and UT can take part in the presidential election, but it is not mentioned there the name of Jammu and Kashmir yet. So some amendment is needed in the article 54 to allow Jammu and Kashmir MLAs to take part in the presidential election. So the Delhi and Puducherry was added in the article 54 to take part in the presidential election in the year 1992 according to the 70th Amendment Act 1992. This is the important things which defense aspirants should know that. Now comes the indirect method is adopted because the size of the electorate in India is too big. So indirect method is indirect method is there to cast the election. So how this? So again we need to come back to the the system of proportional representation. So let us understand now what is the proportional representation. So all MLA will take part, elected MLAs, and all elected MPs will take part in the presidential election, except now the new term is there regarding the Jammu and Kashmir. It is not yet clear that Jammu and Kashmir MLAs will take part in the coming presidential election or not. That is the question. So let us now understand what is proportional representation. Proportional representation, in this you will have to understand a bit mathematics of that. So all the how it is calculated, in which we will understand what is the value of vote given by one MP and what is the value of vote given by one MLA. because the vote given by one MP and one MLA are not equal, and even it is not equal to 1, it is more than that. How it is calculated? It is calculated as the total number of constituencies are there, right, in the state. So population of complete state is divided by the total number of MLA of that particular state into 1000. So that into 1000 is the MLA into 1000, and in the numerator that is the total population of the state. So what is coming out, the result gives the value of a vote of one MLA. I think it is understood to all of you. Once again I will repeat, the value of vote of one MLA is equal to the total population of the state divided by total number of MLA of that particular state into 1000. So 1000 is there in the denominator. Okay, the exact value comes that is the value of one MLA. Now what is the value of one MP vote? It means that is the proportional representation is there. So which proportion is represented by the one MP? So that is calculated according to the total vote value of all MLA divided by all MPs taking part in the election. So in this there is no division by 1000. That's it. That's the value of one MP. Right. So that way the total calculation of vote is done. So system of proportional representation is understood to all of you. Then comes the single transferable vote. So the total vote is calculated. Now single transferable vote. So how the single transferable vote is calculated? That in a secret ballot. First of all, the voting is done by the secret ballot paper for the presidential election. Not EVM is not used. Okay. So how it is calculated? In a ballot paper there will be the preference given by you. For example, if there are 5 to 7 candidates in front of electors, there are 4 to 5 candidates named, and those electors will have to give preference to which candidate he wants to give his vote as a first preference, then priority 2, priority 3, priority 4, and that way it will go. If a particular candidate is unable to secure quota, what is quota? Quota is the total vote casted divided by 2 plus 1. Plus 1 is in the result. It means 50% plus 1 is the quota. So if a person gets quota, achieve that quota, then that particular candidate becomes the president of India. If that person is not getting quota, then his name will be rejected and will be deleted, and the electors who is taking part in the presidential election will his priority get transferred to the next one. So that is the meaning of means of single transferable vote. Okay. So now I think it is all is clear. Indirect method is adopted, that is understood. Direct election of president would mean a tremendous loss of time, money and energy. So now gentlemen, ladies and gentlemen, you understood what is the meaning to having indirect election for the president of India. So there is no direct election because it will be loss of time, money and energy. Okay. Why India is not accepting to bear, and why Indian constitution system is not accepting to bear this time loss and money and energy? Because as B.R. Ambedkar has quoted or has given the statement that as president is just a nominal head, not a direct execution doesn't comes under the president of India. It is just for the namesake, but the direct execution is run by the cabinet ministries and which is headed by the prime minister. So why to waste money, time and energy to elect president in such a large in the process of direct election? So that direct election is done for the MPs and MLA, and out of the MPs, prime minister is elected from that majority party, and then prime minister is appointed by the president of India. Next comes the procedures. Article 55 of Indian Constitution deals with the procedure of the presidential election. Election of president shall be held in accordance with the system of proportional representation by means of single transferable vote. I have already explained you proportional representation by means of single transferable vote. If till now you are not getting any of the point, you can write down in your piece of paper, and at last, after completion of my lecture, when I will be facing to you, at that time I will just clarify you down. Next, secure absolute majority in the presidential election. Then comes the quota, that is 50% plus 1. That already I have explained it to you. Various states are unequal in populations, so there is the what we say, the MLA's value is calculated, and then the strength of legislative assembly is not uniform. So for that case of only we have a different MLAs will have different value of their vote. Votes cast by different MLAs in different states are decided by a definite formula that already I have told you. The total values of one value of one MLA will be total population of the state divided by the total MLAs in that state into 1000 in the denominator, and the results gives the value of one MLA's vote. Next comes the qualification. What should be the qualification and eligibility criteria to become the president of India? That person must be the citizen of India, that is guaranteed. of India. First thing. Second, should must have completed the age of 35 years of age. So sometimes it is asked what is the minimum age of for the to become the presidential candidate in India. That is the 35 years of age. Okay. Then comes now this point is a bit the next point which I am going to explain you. It is a bit concept based. You need to understand it when you pay attention on this. So qualified for the election as a member of the Lok Sabha. So that particular person must be qualified as a member of the Lok Sabha. It doesn't mean that he should be the member of the Lok Sabha. Most of the time it is seen that okay. So the president of India must be qualified for the election as a member of the Lok Sabha. It doesn't mean that he should be qualified for the he should be the member of Lok Sabha. No, that is not like that. He should be qualified for the election as a member of the Lok Sabha. Okay, so that eligibility qualification should be there. Then comes not hold any office or profit under the government of India, state government of any local authority. So not hold any office of profit. So what do you mean by office of profit? Most of the time we see that the office of there is some most of the time doubt in the office of profit. So office of profit is a person should not held any other office through which they are that person is getting some kind of profit. It means the profit of monetary profit, you can say. So that person should not hold any office of profit. Okay, under the government of India, state government of any local authority. Okay, shall not be member of either house of people or house of legislature by any state. So even if they are the member of any of the house or at the post of any of the government posts, then they will have to leave that post once they becomes the president of India. Okay, they are the qualification. Then comes terms of office. It is understood and known to all of you that is the 5 years from the date on which he enters upon his office. Then eligible for re-election. So Indian president are eligible for re-election as many times they can, and his office can be terminated in either of two ways. So how the office of the president can be terminated? First is that by resignation in writing under his hand, addressed to the Vice President of India. So sometimes question is asked that President of India submits his resignation to whom? किसे करता है अपनी resignation submit? To the Vice President of India. Then comes by removal of violation of constitution by the process of impeachment. So ladies and gentlemen, one thing here we need to be very clear that this point is not mentioned in the constitution, but the president can be impeached on the ground of violation of the constitution by the process of impeachment. Okay, the process of impeachment that can start from Rajya Sabha or Lok Sabha, wherever the provisions can start. 15-day notice should be given to the president before discussing the impeachment process of the president, and then that has to be passed by the special majority of 2/3 present and voting from both the house. Okay, then the president will be considered as the impeached, and president have full right to sit in the impeachment process. Next comes impeachment process. Yes, already I have told you. Now again we will discuss Article 60. It is mentioned in the Article 61. A formal, what is the impeachment? That is the formal removal of the president from his post by constitutional means. Okay, he is impeached for the violation of constitution. However, the term is defined nowhere in the constitution. Already I have told you. The charges can be preferred by either house of the parliament. However, a 14 days notice shall be served to the president before the acceptance of such a resolution. Okay. So 14 days notice must be given to the President of India. Then comes also that notice must be signed by at least 1/4 members of the total members of that house which initiated the charge. So that should be signed 1/4 members, and after the acceptance of that, which notice we are talking about? The notice which will be given to the President of India, the 14-day prior notice, that notice must be signed by 1/4 of the members of the house which is issuing that notice to the President of India, that after 14 days we are going to discuss your impeachment in the house where from the notice has started, either Rajya Sabha or Lok Sabha. Okay, so that notice should also have been signed by the 1/4 of the members. After the acceptance of that bill in that house, that impeachment bill must be passed by the majority of 2/3 of the total membership of the house. Okay, then that bill goes in another house which should investigate the charges, and the president shall have the right to appear to be represented at such an investigation. So whenever this investigation discussion is going on, president has right to come and sit and be the part of that discussion. If another house sustains the charge and finds the president of violation and pass the resolution by 2/3 of the total membership of the house, again another house finds that yes, finds the president of violation, it means yes, president must be if another house also agrees with total of majority, then the president from that day onwards is removed. Hence, the impeachment is just a quasi-judicial process. Quasi-judicial, it means it is not directly judicially process. It is a semi-judicial, you can say. So no any judicial body is sitting and deciding and removing the president. No, it is just a quasi-judicial. That is why it is known as the quasi-judicial, because direct involvement of the advocate and judges are not there. And though the nominated members of the parliament do not participate in his election, but they take part in the impeachment process. You must not forget that. What was the electoral college? The nominated members of the parliament doesn't take part in the presidential election process, but the in their impeachment, nominated members also take part in the impeachment process. Also, states legislature do not have any role in the impeachment process. So only parliament, the member of parliament, take part in the impeachment process, represented at such an investigation. Then comes the powers of the president. We will now discuss the powers of the president. Article 53, executive powers are vested in the president. Article 53 says executive powers are vested in the president, but real executive is enjoyed by the council of ministers, cabinet of ministers headed by the prime minister of India. Yeah. Head of the executive power of union. So president of India is just head. What we say, the constitutional head, nominal head, we can say titular head of this executive power. Not answerable to any court with exercise of his powers. So he is not answerable. It means any of the the cases cannot be run on his name. Enjoys certain personal and legal immunities. What we say, the president of India enjoys certain personal and legal immunities. It means none of the cases can be carried out on the president of India. If it is necessary, then civil proceedings can be carried out, that too on the prior notice given to the president of India. Then comes the powers of the president. We will now discuss in detail. Here it is classified the executive powers, legislative powers, financial powers, judicial powers. We will also discuss some of the emergency powers and some of the miscellaneous powers of the president of India. Let us now discuss first the executive powers. What are the executive powers is borne by the president of India. Powers are vested in president, exercise the powers directly or through his subordinates. So what to understand from here, that the president of India will not directly take part in the executive powers of the president, but it will be enjoyed sometime directly or sometime through his subordinates. So through the officer or the person assigned for that. Supreme Command of Defence Forces, already I have told you. Article 72 says to power to grant pardons, reprise, respites or remission for punishment. So president has power according to Article 72 to pardon some punishments, to replace that punishment, to reduce the period of punishment, to change the punishment. That power is there in the president of India. Even president of India can completely pardon, completely forgive the punishment given by the Supreme Court or High Courts. Then to remit or commute the sentences of any person convicted of any offence, to reduce or to change that, substitute the punishment. Next comes the appointment of PM. Yes, Prime Minister is appointed by the President of India, and then with the advice of PM make other appointments like Attorney General, Chief Justice of Supreme Court and those of High Courts. So that is done. Then comes the member of UPSC. Member of UPSC are again appointed by the President of India. Election Commissioner appointed by the President of India. Governor of a state, Chief Election Commissioners of Union Territories, etc. These all are Chief Commissioners of Union Territories, etc. are appointed by the President of India. Every appointment in central government is in the name of President or under his authority. These are the executive powers of the President of India. Represent the nation in the eyes of foreign countries. So any decision, any diplomatical decisions are taken, bilateral decisions are taken on the name of the President of India in the foreign eye, with the foreign countries. Sends and receives ambassadors and other diplomatic agents from other countries. War and peace are declared in his name. So any of the war and peace are declared on the name of President of India. It means presidential direction is the final direction, but it is again decided by the cabinet ministries and council. Cabinet ministries mainly it is decided, which is headed by the Prime Minister. Sometimes the state minister for a state are also called if it is needed in the cabinet meeting. Then comes war and peace are declared, that is understood, can issue directives to the state governors in certain executive matters. So in executive matters, President of India can provide direction. Some kind of direction can be given to the governors, as governors are appointed by the President of India. Next, I'm responsible for the administration of union territories. So union territory, any kind of administration is directly under the hand of union territories, but it is executed on the person appointed on behalf of him, like Lieutenant Governor. Okay. Then comes, under certain conditions, he can remove Chief Justice of India, other judges of Supreme Court and High Court. So these topics are to be covered in the Supreme Court and High Court chapter. But here just I will give you a small glimpse of that how the Chief Justice and Justice of India and other judges are removed. So for the removal of judges and of the High Court and Supreme Court and the Chief Justice of India, a special two-third majority, the bill or the provisions must pass from both the house with two-third majority, a special majority what we say, and then the president's consent is taken, and then that member is removed from his post. Can remove chairman and members of the Union and State Public Service Commission. Now let us discuss regarding the legislative powers of the President of India. Cover a wide field. What are these integral part of the legislative process? Yeah, President of India is the integral part of the legislative process. When we talk the parliament, in parliament is comprises of Lok Sabha, Rajya Sabha and President of India. So the President of India is the integral part of the legislative process, because in every bill, in every every law, new laws, president assent is absolutely taken. Without the president sign, that bill is not passed. Right? Someone's now assent to pass any money bill by parliament to become law. Money bill is again different things. For money bill, well, it can only start from the Lok Sabha, and for the money bill, president 14 days prior recommendation from the president is needed, and whether this bill is a money bill or not, it is decided by the Speaker of the Lok Sabha. Then comes summons prorogue the both houses of the parliament. Summons, you understand that before the first meeting, president can summons the Lok Sabha. And prorogue means when there are three parliamentary sessions, so there is a gap between both the sessions. That gap, means after completion of one session, when parliament is going on break, then that term is called prorogue. So at that time, president will prorogue the session. And the both houses of the parliament, that is understood, can dissolve Lok Sabha. Once the Lok Sabha has completed its tenure, then Lok Sabha get dissolved after 5 years. So it is again by the President of India. Select, nominate members in the Lok Sabha, and that we understood Anglo-Indian members are nominated till the Jan 2019, but Jan 2020. But from after that, this is not compulsory that these two Anglo-Indian will be nominated by President of India. Now, what are the next legislative powers of President of India? Certain bill needs prior assent to the President before the Parliament, like money bill. Prior assent is needed in that. He may withhold his assent or may return the bill to the House of reconsideration on the line suggested by him. So, President also have some veto power that we will discuss. Formation of state boundaries, alteration of area or names of the existing states needs to recommendation of the President. Again, new states formations, boundaries, alteration. So Article 2 of Indian Constitution says give power to the Parliament of India to reorganize the states, alter the boundaries, change the boundaries of the state. So that is again done by the advice. That is again done by the consent of the President of India. Then comes take over the administration of the state. Yeah, in the president's role, state's administration comes under the president administration. Then comes under the president only, the state administration comes. Exercise veto on the advice of the Union Cabinet. Again, veto power is used by the President of India on the advice of the Union Cabinet. So that veto power also we will study in the detail now. Next, the financial power. What are the financial powers that our President of India bears? Like every financial year goes to lay before both the House of Parliament a statement of the estimate receipts and expenditure of Government of India for that year. So that report, the report is submitted by the Finance Commission, is again addressed to the Parliament of that particular year to before the Government of India. Then comes can ask supplementary, additional or excess grants, any kind of grants, additional decisions or that can only be asked by the before distribution of any of the taxes. Some kind of grants can be asked from the President of India only. Distribution of taxes among the states. Then money bill. For money bill, prior permission is needed to start. Once the money bill comes in the Lok Sabha, and the money bill which starts from only Lok Sabha, the prior permission is needed from the President of India. Already I have explained it to you. Next come enhancement or reduction of taxes, amendment or abolishment of any taxes. On these things, President's views are taken. So it is considered as the financial power is also there with the President of India. Laid before the Parliament the annual financial statement. What is this annual financial statement? The budget, what we say. The term budget is not mentioned in the Constitution of India. So that is referred as annual financial statement. Report of Auditor General of India and relating to the accounts of the Government of India. What is Auditor General of India? Can anyone tell me? Yeah, Auditor General of India is the highest law officers, right? And the Advocate General is just as the same post in the state is known as the Advocate General. Then recommendation made by the Finance Commission, annual report of the Union Public Service Commission. These all are again introduced by the that is submitted to the President of India, these reports, and again introduced to the Parliament. Then comes contingency fund for unseen expenditure. Contingency fund which is used for emergency purposes in India, that is again that can only again be used in the emergency unforeseen expenditure like some climate change. So in those cases, President of India has power to use fund from a contingency fund, but in that also President of India will have to take advice from the cabinet ministries, which will be headed by the Prime Minister. Then expenditure must be approved by the Parliament. Whatever expenditure has to be granted for particular unforeseen expenditure. Okay, so these are the financial power of the President of India. Then comes the judicial power. So what is this judicial power? So enormous judicial power President of India bears. Grant pardon, already we have discussed that any of the criminal cases can be forgiven by the President of India. Reprieve, cancel or postpone the punishment. Punishment can be postponed or it can be cancelled completely. Then comes the respite, a short period of rest or relief. So respite is if any punishment is given for some acceptable reason, like for in case of woman, if pregnancy is there, in that pregnancy case, that punishment will be kept. It means short period of time it will be rest, or the punishment will be relieved, or it can be again for the particular duration of time it will not be applicable. So respite, that power is again with the President of India. Remission of punishment, the cancellation of debt or charge or penalty, so again that power is also there. Suspend, remit, commute the sentence of any personal convicted of any offence. Already we have discussed. The sentence also can be pardoned by the President of India, sentence, death sentence and all. Where the punishment is by court martial, in all cases the sentence is one of death. So the court martial which is done in the military platform, so that also can be pardoned by the President of India. But this power, court martial power and the sentence to death, sentence to death, these punishments are not pardoned by the governor of state. So that is understood. Okay, like this governor of a state also has this power. Then comes judicial power, is also that president is above law. Already I have told you that most of the time presidents cannot be any of the conviction cannot be done on the president. If president found guilty, then also any charges cannot be applicable, just to respect the dignity of the President of India. But some civil proceedings can be carried out, or that too also on the prior notice to the President of India. Not subject to the scrutiny of any court, that is already explained. Appoint judges of High Court and Supreme Court. Yeah. Then Article 143. He can ask Supreme Court any questions of law or fact of public importance for its advisory opinion. Okay. So President of India can ask for the advice, and for any of the advisory opinion can ask Supreme Court on any question of law or fact, according to the article number 143. Sometimes it is asked in the examination, so the article is mentioned. Okay. Approval is necessary for the rules made by the Supreme Court for regulating practice and procedure of the court. So that approval is necessary for the rules made by the Supreme Court. Approval is the President's approval must be there. Okay. Next, emergency powers. The very important topic is that this is emergency power. Deal with unseen contingencies. Like Part 18 deal with the emergency powers. 3 kind of emergencies are there. What are these 3 kind of emergencies? Now we will discuss. Like arising war or external aggression and internal aggression. So this internal aggression, earlier before 1975, it was known as the internal disturbances. Then after in the 42nd Amendment Act of 1976, it was changed to the armed rebellion. So only and only national emergency will be declared on 2 reasons. First is the external aggression. External aggression in case of any war with the neighboring countries or any foreign countries, and on the ground of armed rebellion, that is the internal aggressions, armed rebellion. So what armed rebellion was replaced in the Amendment Act, 42nd Amendment Act of 1976. Okay. Before that, what was it? Before that, it was the internal disturbances, which includes any kind of internal disturbances, whether it is the armed disturbances or not, the emergency can be declared. So that ground is not here, right? So till now only 2 times national emergency has been declared. That was after the 1962 Indo-China War and in the year 1975. Next comes the breakdown of constitutional machinery. When breakdown of constitutional machinery is there in any of the state, then the President rule is applied. That also comes under the emergency only, that is the President rule. Third is the financial emergency. The President rule has been implemented more than 100 times in India, and the financial emergency has never been implemented. Now let us discuss the national emergency in detail. Emergency condition must laid before the House of Parliament. Conditions must be there. Article 352 deals with the national emergency. Issue of proclamation of emergency. Then comes remains valid for an indefinite period unless President revokes it. So again, so this national emergency is for indefinite period, but it can be changed on the advice of the cabinet ministries by the President of India. On 25th June 1975, hatred of internal threatening the very unity and integrity of India. So that was the national emergency implemented in the year 1975. Okay. So then after the term and the condition for the national emergency was also amended in the 42nd Amendment Act of 1976. Then come the constitutional emergencies, that is what we say the president rule. Article 356 deals with that president take over the administration of the state, that is on the advice of the governor of that particular state. President's rule of emergency, what we say, that is president's rule. Okay. Generally it is known as the president rule. Then governor of a state is not satisfied with the situational arises, state cannot be carried on in accordance with the provision of the constitution. What does it mean? It means that when government of the state fails to make, when the winning parties or the parties of that particular state fails to make government, then on the advice of governor of that state, president rule is declared according to Article 356. And that has approved by parliament within 2 months, remains in force for 6 months. See, so this what we say president rule in a state can remain only for a month of 6 months, and again it can be renewed. That is, it can be again renewed. There is no objection in that. Can be extended for another 6 months. Except High Court, all the functions of state government are taken over by the president. So what happens in this? That High Courts will keep on working as it was working earlier. But apart from that, except High Court of that particular state, all the functions will be come under the President of India. Then comes the financial emergencies. According to Article 366, it is proclaimed situation arises that the financial stability in India or any part of it is threatened. So financial stability is not there. Then there will be the financial emergency. Remains valid for an indefinite period. Again, there is no definite period for the financial emergency. It can be decided by the President of India. Okay, approved by the Parliament within 2 months. It should be approved that financial emergency within 2 months. And salary of any state government or union government servants may reduce. What happens in this? Though any of the salary of the personnel of the state government, union government, that get reduced. Allocation of revenues between central and state may be altered. So the revenue distribution to the particular state can be changed. The earlier formula will not be followed under this provision. Financial emergency. President may give direction to the state. So president may give direction to this. One more point I would like to add into the national emergencies. That is the point is that during the national emergency, any of the laws can be made which may violate some of the fundamental rights. But those laws again will not be applicable after the emergency is uplifted. The national emergency is uplifted, and you cannot even claim any of the case, or you cannot even claim any of the case against that law which was made in the that national emergency. That is one of the points which you need to understand regarding the national emergency, which already I have explained. Next, now let us come to the veto power of the President of India. The absolute veto, President of India has some. There are some of the bills in which the President of India can apply absolute veto. It means the moment absolute veto is applied, the bill is rejected and it will not be passed. Suspensive veto, President of India will send the bill for the reconsideration to the legislation where from the bill has started. Okay, that is the suspensive veto. Once the bill has already reconsidered and coming back to the President of India, at that time President of India is bound to sign that bill. Okay, then the pocket veto. Pocket veto is, in this veto, President of India can apply pocket veto on any of the bill. There are some some kind of bill in which if on any bill this pocket veto is applied, then even President of India doesn't know when that bill is going to be renewed. That is why it is said that the pocket of the Indian President is larger than that of the USA President, because in USA President there is some valid what we say term or duration for the pocket veto. But here in this there is no validity of the duration. It can go as long as President wants. Then next comes President has no veto power in constitutional amendment bill. That has to be understood. Then now ordinance making power. It is one of the most important power which President of India enjoys according to Article 123. What is this ordinance making power? When the session is not in the when the session is So when the President of India, when the session in the Parliament is not in acting, so the President of India have right to give ordinance, can make ordinance for any special cause. So an ordinance can be issued by the President only when both Houses of Parliament are not in session, or when only one house is in session. Okay, the ordinance must be approved by the parliament within 6 weeks of its reassembly. Hence, the maximum life of an ordinance is 6 months plus 6 weeks. So, once the ordinance is made, its validity is for 6 months, and within that 6 months, if parliament comes in the session, then that validity ends and the 6-week validity starts. Within that 6 week, parliament has to pass that bill. Okay, next comes, hence the maximum life of an ordinance is 6 months plus 6 weeks. He can issue an ordinance only on the advice of the Council of Ministers headed by the PM. Then miscellaneous power instruction to the governor can be passed by the President of India. Refer any questions of public importance for the opinion of the Supreme Court. Already we have discussed according to Article 143. Then appointment certain commissions like report on administration of scheduled areas and welfare of scheduled tribes and backward classes, finance commission, etc. Admission of tribal areas, etc. So these all comes under the power of President of India. Power and responsibility as regarded scheduled castes and tribes. So scheduled regions, scheduled castes, scheduled tribes, these powers are again borne by the President of India. So this was all about the today's session on the President of India.